Hello everyone, I am Ashok Kumar Jain, Member Secretary, National Legal Services Authority. I and Mr. Sunil Chauhan will be covering the framework and other related aspects of providing legal assistance at early stages of criminal justice in India. I will give overview of the legal services institutions and thereafter Mr. Sunil Chauhan will elaborate the framework relating to providing of legal assistance at early stages of criminal justice in India. Legal services institutions in India are legislatively mandated to provide legal aid to weaker and marginalized sections. The Constitution of India under Article 39A mandates state to enact legislation to ensure that people do not remain deprived of justice because of economic or other disabilities. Accordingly, the Legal Services Authorities Act was enacted by the Parliament of India in 1987 and it came into force in the year 1995. It has established legal services institutions across the country. This legislation spells out the functions of these legal services authorities. It also spells out the categories of people eligible for legal aid in India. If you see organogram, National Legal Service Authority or NALSA is the apex authority which is headed by Honorable Judge of Supreme Court of India as Executive Chairman and Honorable Chief Justice of India as Pattern-in-Chief of the body. It tasked with making legal aid policies and programs for the country and monitoring legal aid programs across the country. We have robust network of legal services institutions in every corner of the nation. There are 37 state legal services authorities who devise and monitor legal aid at the state level and report the same to NALSA. Similarly, we have one Supreme Court Legal Services Committee to provide legal aid and assistance to poor and needy at the Supreme Court level. 39 High Court Legal Services Committees to provide legal aid in the High Courts, whereas 672 are at district level and 2,282 at subdivisional level. Thus, the presence of legal aid institutions is in every district of the country, including remote and far-flung areas. It is very unified network and is manned by judicial officers. Our workforce consists of around 48,000 panel lawyers and 47,000 paralegal volunteers. The activities conducted by legal aid authorities across the country can be broadly classified into 4 categories. First of them is legal aid and assistance, in which legal assistance to eligible categories is given in the form of legal advice, legal representation, and drafting of petition and application, etc. Second program is legal services outreach activities, which consist of legal awareness programs to enhance the capabilities of people and other outreach activities to identify the legal needs of the people. Third program is implementation of alternative dispute resolution mechanisms such as Lok Adalat and mediation. ADR mechanisms implemented by the legal services institution are free to all and millions of cases are settled through these mechanisms. Fourth program is victim compensation scheme. State-sponsored victim compensation schemes to rehabilitate victims of crime are implemented by legal services authorities. Now I request Mr. Sunil Chauhan to elaborate the framework relating to legal assistance at early stages of criminal justice. Mr. Chauhan.
Thank you, sir. Hello, everyone. Before I delve into the framework of legal assistance at early stages of criminal justice, let me give a glimpse of the scenario related to arrests. In India, around 5.2 million people are arrested in a year. Out of those, around 3.3 million, that is about 64%, are released on bail at the first instance, and around 1.8 million arrested persons are admitted in prisons. There is no doubt that many arrests are unnecessary. At the end of the year, if you see the scenario, there are around 330,000 under trials in the prisons at the end of the year. The Constitution of India and other legislations contain various provisions which provide the framework for providing legal assistance at the early stages of criminal justice. For instance, Article 21 of the Constitution of India declares right to life and personal liberty as the fundamental rights. It says that a person cannot be deprived of life and personal liberty except in due course of law. Article 22, Clause 1 of the Constitution of India provides that a person arrested has a right to be produced by the police before a magistrate within 24 hours, and he has the right to consult a lawyer. Section 12G of the Legal Services Authorities Act 1987 provides that a person in custody is entitled to free legal aid. Section 41D of the CRPC, that is Code of Criminal Procedure, provides that an arrested person has a right to legal aid. Uh, Indian judiciary has contributed quite a lot in developing jurisprudence of right to legal assistance to an arrested person. For instance, way back in 1978, Supreme Court of India, in one of the cases titled Nandini Satapathy, held that if a person is in circumstances of near custodial interrogation, then also he has a right to legal assistance. In another case titled as Sheila Barse, the Supreme Court held that if a person is arrested by a police, then the police shall send intimation of the same to the legal aid committee. NALSA, since its inception, has also taken various steps to ensure such assistance at the early stages. For instance, in the year 1998, a scheme was developed by NALSA with the purpose to depute certain lawyers in magisterial courts, so that when an arrested person who is unable to engage a lawyer is produced before a magistrate, he is represented by a legal aid lawyer at a pre-trial stage. In 2015, an amendment was made in the regulation 2010 by NALSA for opening legal aid clinics in the prisons. In 2016, SOP was prepared for streamlining the working of these clinics. In 2019, a very important and very comprehensive policy was framed by NALSA for providing legal assistance in police stations as well as in the courts at the initial stages of criminal justice. This NALSA's protocol contains the operational framework, including the role of deputed lawyers for providing timely and effective legal services. It also spells out the role of legal services authorities, also what they have to do. There are three early stages of criminal justice in India. Those stages are pre-arrest stage, arrest stage, and remand stage. At the pre-arrest stage pertains to a suspect when he is called to the police station for interrogation. Uh, Arrest arises when a person is arrested and he is in a police station. He is yet to be produced before the magistrate. Remand stage is a stage when a person after arrest is produced before the magistrate for seeking his further custody. We have deputed around 8,000 lawyers for rendering legal assistance at these three early stages. If you see the number of police stations, there are around 16,833 police stations in the country. And on an average, one deputy lawyer is covering around two police stations. Before I proceed further, let me point out some of the unique features of legal aid to a person in custody. Means test is not applied to a person in custody. He is entitled to free legal aid irrespective of his income. Even if a foreign national is in custody in India, he is entitled to free legal aid. With regard to merits test, it is presumed that a person in custody has prima facie case in his favor for legal aid. Legal aid is available in all the courts, that is in trial courts and appellate courts. For instance, if a bail application is rejected by a trial court, then we provide legal assistance for assailing that order in the higher courts. Legal aid is available on all the days, including holidays. Government of India funds the entire legal aid programs in India. NALSA is following a five-point strategy for effective implementation of its protocol for providing legal assistance at early stages of criminal justice. The 5 point strategy consists of spreading awareness among us people, training of legal aid lawyers, sensitization of police officer, ensuring quality of legal assistance, keeping in view the performance indicators, and deputing male and female lawyers as per the perceived requirement and sharing their contact details in advance with the police stations and courts. Legal awareness programs are held across the country. For instance, in 2021, around 126,000 programs were held across the country. In these programs, people, apart from other laws, people were also made aware of their right to legal aid. These programs were attended by around 13 million people. Training programs for panel lawyers are also held. NALSA has prepared 3 training modules in a year. Around 1,400 training programs are held for panel lawyers. They are also trained in the various processes which they have to follow while rendering legal assistance at early stages. In NALSA's protocol, as I mentioned earlier, we have a very comprehensive framework which spells out what is to be done by a legal services authority and what is to be done by a lawyer. The duty rosters are sent by the legal services authorities well in advance to the police station and to the courts. Now, what lawyer has to do? At the pre-arrest stage, a lawyer first of all has to apprise himself of the allegations against the suspect. He has to explain the alleged offense to the suspect. If a person does not understand the language, then an interpreter is hired. If a suspect is a foreign national, then a duty lawyer also ensures that proper intimation is given to the High Commission, Embassy, Consulate. If the police proceeds to arrest a suspect and it appears that such arrest is unnecessary, then a lawyer has to apprise the police about the position of law. At the arrest stage, also, if a person is arrested in a bailable offense, then a duty lawyer provides requisite legal assistance in obtaining bail at the police station itself. Lawyer ensures that safeguards available under the law for an arrestee are translated into action. A remand stage is very important here. Also, the lawyer role of a lawyer can make a difference. If police arrests a person illegally, then such illegal arrest is challenged before the magistrate at the stage of remand. Bail application is moved, the further custody sought by the prosecution is opposed. If a person is suffering from disability, then proper steps are taken. If a person is unable to understand the language, an interpreter is arranged and legal services authority pays for the same. And now the implementation status. At the remand stage, despite the fact that 2020 was a challenging year because of pandemic, we succeeded in providing legal assistance to around 76,380 arrested persons. We filed bail applications in around 36,000 cases, and out of those, 57% of such applications were allowed. At the pre-arrest and arrest stage, that is in the police station, the momentum is picking up. Now the challenges. There are many challenges. One of the challenges is that timely information about suspects and arrested persons is not received from the police officers. Primarily, this is also because of lack of awareness on the part of police officers. Another challenge is reluctancy on the part of suspects to avail legal assistance because of their poor understanding of its significance. It is also difficult to provide the legal assistance and at odd hours in hilly and remote areas. Monitoring challenges are also there. Monitoring framework at the implementation level, no doubt, is being improved so that every case is tracked. During COVID also, we faced many challenges. It was very difficult to conduct interactions with suspects and arrested persons. In most of the cases, particularly during lockdown, it was not clear whether the suspects had taken informed decisions for not availing legal assistance. Monitoring aspect during that, particularly during lockdown phase, also remained quite weak. We have some quality assurance measures in place. A lawyer must have a minimum of 3 years law practice for getting impaneled with legal services authorities. Training is mandatory for panel lawyers. If they do not attend trainings without any reasonable cause, then they can be depaneled. Monitoring and mentoring committees are functional. Documentation and reporting is mandatory. Documentation is done on prescribed performance. NALSA has provided those performance to all the state legal services authorities and district legal services authorities. Uh, Apart from NALSA's protocol, we have certain other supporting methodologies which also help in identifying the legal needs of the arrested persons at pre-trial stage. As I mentioned earlier, we have legal aid clinics, and these clinics help in identifying pre-trial prisoners who require legal aid. We have under-trial review committees across the country, which are headed by a judicial officer. A periodical review of under-trial prisoners is done by these committees. Pre-trial prisoners who can be released on bail are identified, and accordingly, recommendations are made by these committees, and these recommendations are also shared by the committees with the legal services authorities, and we accordingly appropriately respond to the same. This also provide helps us in identifying the prisoners in need of legal help. This is the scenario relating to legal services clinics. In 2021, legal services clinics provided legal assistance to 143,000 arrested persons, prisoners. Under trial review committees also hold around 2,000 meetings per quarter to ensure to enhance the implementation strategies. NALSA is now focusing on having consultation with legal services authorities. For instance, recently a 5 days consultation was conducted by Executive Chairman NALSA with all the state legal services of the country, and it provided the platform to identify the gaps and to find out the possible solutions. We are also focusing on enhancing the capacities of legal services providers, and we are also planning to have joint workshops with police officers for improving coordination. We are also improving our documentation and reporting processes through digital platforms. With this, thank you very much on behalf of NALSA. I also thank organizers of the International Legal Aid Conference for giving us an opportunity to participate in the conference. Thank you very much. We will be happy to answer the questions. Thank you.